I don't know. After hearing him calm and talking about the tether story, it's probable.
Just go down to the county attorney's office. I think you'll find a lot of humans down there.
All right.
No disrespect.
Stop driving.
I'm flirting with the judge in front of my dad.
Probation. What's going on? This is Colin. How's everybody doing? Happy Friday. Hope everyone had a good Thanksgiving. Hopefully you're not too hungover this morning. What is... Oh, I got a tab open and playing. Scared me for a second. I thought the video was playing. Thought I forgot to hit the pause button. Anyways, hello everyone in chat. I saw a lot of people already. Got Hey Jay. Got Peeps, Vicky, Jojo, Phil, Sashina, Jojo, Jody. I saw Rachel, Michelle, everybody that I'm missing because I'm scrolling fast. I'm sorry, but hello. Sashina, I just saw happy birthday. Happy birthday. And yes, if you haven't subbed to her channel, sub to her channel. She has a good channel. All right. Final chapter. This is a long one. It's about an hour and 20 minutes. I'll try to pause it as little as possible, so it's only a little over an hour and 20 minutes. Kind of cram the rest of it into this. So we're going to see the second witness, which is the last witness. Then we're going to see closing statements and the verdict. Hope you all ready. Oh, Rachel. Yes, I need to send you that link. I need to look it up. So I got to go through my my subscriptions and find the link, but I'll do that. You were supposed to remind me yesterday. You didn't remind me, or I wasn't really around on Discord too much, so I might have missed it. Anyways, all right. Before I hit the play button, you already know what to do. Like and subscribe, do your jump kick backflips. As always, Linktree is in the description. If you would be so kind and donate, I would very much appreciate it. All right, let's go.
When are we going to break for lunch, Judge?
We're going to break for lunch when we complete the next witness that the state has, or noon. If it's earlier than noon, we'll break before noon.
So you're saying we don't have a recess right now?
We do not. We have a trial to do, Mr. Frog. That's what
Okay, bring back the state trooper and I'll do the best I can.
we're moving on from that. There are consequences to these decisions that you make, Mr. Frog. So one of them is you forfeited the remainder of your prosecution by not doing it.
I have to use the bathroom, Judge.
Following that, Mr. Frog. Let's bring the jury back in here and call the next witness.
Resulted in removing that. He didn't say anything to.
Yes, you multiple times to continue the processing, refuse to do so.
Well, the jury is likely gonna favorably decide in my favor because of the eliminating the trooper, Judge. And that's optimistic observation in your favor.
And the members of the jury, Trooper Jackson's testimony is excluded and the state will be calling in his witness.
Your Honor, the state calls Natalie Jackson, or Natalie Grunzer, I'm sorry.
Natalie Brown.
Yeah, please no spoilers. I know a lot of people have seen the end of this, but if you do know the end, don't say it in chat, please. Thank you.
And Your Honor, whenever you're ready.
Could you please state your name and spell it for the record?
Natalie Gronzo, Gronzo.
Thank you. And are you employed?
Yes.
Where are you employed?
The Washington State Department of Licensing.
What are your duties?
I respond to various entities for drive record requests as well as testifying in court.
And do you deal with driving records in your ordinary course of business?
Yes.
Are you familiar with the Department of Licensing suspension process? Why might someone's license be suspended?
It could be suspended for various of reasons.
Could you please describe the suspension process for the jury?
It could be reckless driving, DUI conviction.
Thank you. And I'm handing you what's been marked as State's Exhibit 3. Can you identify this document?
Yes.
What is it?
This is a certified copy of a drive record.
Does the document have a state seal?
Yes.
Does the document have an official seal of the Department of Licensing?
Yes.
And who generates the document?
The Department of Licensing.
Does the Department of Licensing prepare these documents in the regular course of business?
Yes.
And can you tell whose driving record this is?
Yes.
And whose is it?
It looks like a Nabil Farag.
And how can you tell that it's that driving record?
It states on the sheet.
And the state moves to admit State's Exhibit 3.
The objection to States 3 being omitted. It's exhibit number 3 will be admitted.
And what does this document indicate with regards to that person's driving status?
That they were suspended or revoked at the time.
And are you able to tell from this document on what dates they were suspended or revoked?
Yes.
Yes. And according to this document, what was the driving status on July 16th, 2021?
Happy birthday, Mayor, if you're there. Also, Jody, I hope you recover quickly.
It looks like I'm not seeing that date. It looks like he was suspended at the time. Sorry.
Thank you. Handing you what's been marked as State's Exhibit 2. And can you identify this document?
Yes.
What is it?
This is a letter of suspension.
And how is this document generated?
This should be, Your Honor, I didn't hear a letter of what?
She said a letter of suspension.
Your Honor, the courtroom is so large and I haven't, I missed something you said yesterday as far as the time to question the jurors. And I missed a word there. This courtroom is too large and there's no microphone, there's no speaker.
Down to the duty of your best
I can
to
speak
elevate
louder,
your
yes.
voice.
Sorry. Could you
How-
say?
Of course. How is this document generated?
It is generated through the Department of Licensing.
Do they prepare this document in the regular course of business?
Yes.
And can you tell from looking at this document who it was sent to?
Yes.
Who was it sent to?
Mr. Nabil Farag.
And how can you tell that?
It states their name on the top.
State moves to admit the State's Exhibit 2, the Department of Licensing letter.
Objection to Exhibit 2 being admitted. And State's Exhibit 2 will be admitted.
And what does this document say in regard to Mr. Farag's license suspension?
It states that he will be suspended if he does not appear compliant.
And when was this document sent?
April 26, 2021.
And does this document give Mr. Farag an opportunity to prevent the suspension?
Yes.
Thank you. The state has no further question.
All right, and Mr. Farag, do you have any cross-examination questions for this witness?
Your Honor, just one more.
Sorry. Hold that one moment. Go ahead, Mr. Robbins.
Hold on, Judge.
Who's ready for this? Also, hello everyone that
Appreciate-
came in a little late.
Hold on one second, Mr. Farag. Mr. Robbins actually did have one.
Just to clarify, one final question. On July 16th, 2021, what was the status of Mr. Farag's license?
He was suspended.
Thank you. State has no further questions.
He was what?
Suspended.
Okay, now it's your turn for cross-examination.
It's about to go down. I like how the state took 5 minutes. This witness sits on the stand for about an hour. The state took 5 minutes of that.
Your name again?
Natalie Gronzo.
Natalie Gonzo?
Gronzo, yes.
Ms. Gronzo. I need to determine and inquire about, did you say you were a public disclosure officer?
No.
You do records requests?
I do.
So you gather the information from other staff at the department?
Not necessarily.
How long you been with the DOL?
A year.
Was that Natalie Gonzo?
Gronzo, Gronzo.
Natalie,
Yes.
and the department, who decides at the department which staff member they assign or dispatch to come to court, such as with you today?
We are each assigned to different zones, and then we just pick subpoenas between our teammates. We all get quite a few subpoenas.
You get quite a few what?
Subpoenas. There is no process.
Oh, okay, yeah, you've been subpoenaed to appear here.
Yes.
Now, the one central thing that I need to determine as to whether there's guilt or no guilt in this case is for the state, the attorneys here to prove that, or to find that all the elements have been proven beyond a reasonable doubt, jury. Did we lose a juror, Your Honor?
Mr. Farag, we want you to
That's
ask
the,
questions of the witness. at
I
this
know,
point.
but that's the juror that was missing.
We covered this earlier this morning. I asked you to continue with your cross-examination. Ms. Gronzo.
Okay, are you familiar with the elements of the driving while license suspended?
Yes.
Okay, so that's part of your training.
Yes.
Now, it says under unnumbered jury instruction 2A, the defendant failed to respond to a notice of traffic infraction and either or failed to appear at a requested hearing or violated a written promise to appear in court or failed to comply with the terms of the notice of traffic infraction.
Yes.
Now, am I derelict in that regard?
Could you restate your question, please?
I say, I repeated, hold on a second, I need to look.
Why doesn't he bring all of his notes for this witness to the podium? And he's back.
Okay, the jury instructions 2A, the defendant to for the state to find beyond a reasonable doubt that I am suspended, it hinges on whether the defendant failed to respond to a notice infraction, or he failed to appear at a requested hearing, or he violated the written promise to appear, or failed to comply with the terms of notice of traffic infraction as provided by RCW. Are you familiar with that RCW?
Yes, I am.
And do you know it offhand?
The number?
Yeah.
No, I do not.
Okay, RCW 46.20.289. Now, are you familiar with this case?
Yes.
Okay, now I have failed, it's alleged that I have failed to comply with all those criteria. Is that correct?
With all the criteria?
Yeah, failed to respond to a traffic infraction, failed to appear.
Objection calls for a legal conclusion, also misstates the law.
Sustained.
Could he repeat that? What was his objection, Judge? I'm trying to write this down.
It misstates the law. And he's providing a legal conclusion.
Okay, what is it that I failed to do in order to result in a suspension?
It looks like you received a suspension letter stating on what you can do to be licensed again.
And that's out of Lewis County District Court. Does that have any discrepancies as far as your examination of this?
I do not believe so.
It doesn't matter which county it is, right?
It is your license in Washington State.
Now, do you you have a form which I think has been used in the past. It's called the administrative review request. What can you tell us about your knowledge of that?
The letter states that if you would like to review the pending action on your driving privilege, you can request an administrative review.
And do they, does the department provide that review?
Does the Department of Licensing provide that review? No, I do not believe so.
Okay, the department is not anything other than DOL, Department of Licensing.
Yes.
So you're saying, you request a review, but there is no review. Is that what you're saying?
No,
There is a review?
yes, it is not up to us to decide whether you are guilty or not.
Okay, so what's the review then? If you don't,
The review is if you would like to request a review for the reason that you are being suspended.
oh, to get reasons why I'm suspended?
If you believe that it should not be there.
And so what does the department provide a motorist who doesn't believe that it should be suspended?
We provide you the letters if you would like to handle it before you get suspended. So you can
Handle it where? Before the department or before the court?
You will send your review to the Department of Licensing.
And do they, what's the extent of that review?
They will look at your record and identify if it is you. And they will look at the information received from the court or other agencies to describe the action that they took.
Which is nothing beyond what they've already issued, right?
It's more of a clarification.
Yeah. And it all goes back and hinges on the court, how they decided the matter.
The court does ultimately decide.
And that's before and during and after, right?
In what sense?
Well, if you seek administrative review, it still goes back to the court, right?
Yes.
Okay, so there's no remedy. There's no remedy before the department. So the administrative review request is,
Objection, relevance.
what did I say that the objective?
Yeah, let me hear the rest of the question.
Well, what, how much did I say before you objected? He's objecting too many times. It's another Wayne Graham. You know, if you can,
Please ask your question.
This is when I want Law Talk with Mike's clip. All of the objections. That would have been a good insert right
so
there.
they do a review, they want an attorney's name. Can't be a public defender. Now, with an attorney, do they provide a review administratively?
I do not work in that department. I would not know.
You would not know? Who would know at your department? Do you have a name?
You could call customer record support.
Yeah, well, we don't have Your Honor, we're missing a critical answer here as far as whether the department issues a review, because the court did not want to adjudicate the infraction, which the administrative review would pick up the slack, but they don't do that, except if you have an attorney. And you can't answer that question because only customer record support. We don't have a name.
I do not have a name. I'm sorry.
Yeah, so,
Objection, relevance, name.
so there essentially there's no administrative review, right?
There is.
And how much is it or how less is it?
In what sense?
Well, you review by just clarifying clarifying the situation, right?
Yes, it's a review of your record.
Oh, it's just to confirm what was already sent to the motorist, right?
Yes, if you are not sure why specifically you are suspended, you can request. to
Well,
have
it's on the form. What more could you be uncertain about that you would answer beyond what's already on the form?
That is up to the license holder.
Now, can you, you are, you
No,
worked for
not
1 year
one
with the
single
department,
argument made sense.
and you mentioned zones. That's the scope of your work according to the zones that you deal with.
We deal with subpoenas across the entire Washington state, and we have a large team of people who respond to them.
Now, what do you know, the work exception? You know anything about a motorist who's suspended who has a work exception?
Objection, relevance.
Sustained.
Okay, what do you know, Ms. Garzo, about the SR 22?
The insurance,
Yeah, insurance.
when you are suspended, you are required to get that insurance.
Now, the difference between that, and I'll ask you here, how much is required to be,
This has nothing to do with insurance. There is nothing in this case that has anything to do with insurance. Why is he asking this question? It's about license suspended. Yeah, he might need to get the SR22 insurance, which is just a higher rated insurance, isn't it? I don't know. But that's the insurance you have to get when you get have a DUI or something like that. You have to have that for a while. But what does that have to do with any of this?
how much insurance to be, or coverage to be required versus self-insurance is 60,000, correct?
Objection, relevance.
Sustained.
Okay, the SR 22, how much is required to be carried by the insurance company?
Objection, relevance.
Sustained.
You
Judge,
tell
I
us
can't keep going with my
anything
argument if
about
he keeps
the
interrupting me.
department, such as the secretary of the department was a woman 8 years ago. Are you familiar with the secretary?
Objection, relevance.
Sustained.
Do you know anything about the driver's guide? Hold on a second.
Objection.
Oh, yes. I forgot he brought out the driver's guide. The little pamphlet you get from the DMV when you want to take the test. Yeah.
Objection.
Oh,
relevance.
this is fun. Objecting to the
What is it?
book.
What are you trying to show to the witness?
What's that?
What is it you're trying to show to the witness?
Well, I mentioned the driver's guide.
Hold on, is that marked?
I only have one copy, Judge.
Would you
I don't
show
want to
that-
submit it.
Before you ask her any questions about it, would you show that to the deputy prosecutor?
It's the current edition of the driver's guide.
We're objecting to being admitted.
We're objecting to this being admitted, Your Honor.
I'm not admitting it. It's my only copy. I have older.
They haven't been offered, but I believe you said you had a question of the witness
Yeah.
regarding, and it's this driver's guide. So why don't you go ahead and ask your question and see.
It looks like a January 19. Do you have any, can you answer any questions in regards to the driver's guide? Do you know what this is?
I do.
Can you answer any questions as to, in the last 10 years, if they've made changes in which areas in this guide?
Objection relevance.
There are two state's attorneys there, two prosecutors. One, the main guy who's trying the case. This
Do
is
you
only
have
his
any,
second. All right, hold on. For the person I asked, this is only his second jury trial, so I'm guessing that the other guy is just maybe his mentor, or I don't want to say boss, but a step above him, just to kind of help him through. That's who I'm assuming that is. But I don't know the actual answer. I don't know if he ever announces himself or anything.
you have any answers as far as the motorist public,
What's up, Pseudo?
the problem type of motorist public?
Could you restate your question?
Well, the motorist public, people on the roadway, involve white people, Americans, such as we see here. They involve black people. They involve
Let's stop here for a second. Members of the jury, I'm going to excuse you here while I resolve another legal issue.
Yeah. Why? In what relevance is race when a license is suspended? Someone explain that to me. Oh, and it gets worse.
In Your Honor,
It gets
I believe this
It's
witness
a
will
lot
need to
worse.
leave the courtroom for the question, unfortunately.
What's
that?
Let deputy prosecutor come.
what do you think?
Oh, she's just going to step off while we just have a discussion here. Let's see, Mr. Crowe. Exology, in the course of this trial today, 2 or 3 different times from you, Mr. Farag, referring to various individuals and somewhat derogatory by their race. And I am directing you to terminate that sort of discussion.
How else do you want me to refer to
one of my
them?
jobs to make
Blacks?
sure that justice is administered in this court fairly and without regard to irrelevant subjects. You've made reference to other people who aren't here disparagingly by their race. You just were attempting to do so here with this witness.
Are you talking about the Negroes, the blacks?
It's unacceptable for you to refer to people or make comments like
I
that.
said
during the
blacks.
course of this trial.
That's not as derogatory as if I would have
It
said
was
Negro.
a completely irrelevant and uncalled for reference to individuals.
And then I was gonna go on to say that there's under young people,
It's
teenagers.
unacceptable in this court to make such derogatory references to people by their race, and you have done it.
How
now,
else was I gonna
think 2 or
refer
3
to them,
times.
Judge?
So when you ask a question, I want you to do so without raising any sort of derogatory racial terms.
Would referring to them as people of color be more suitable?
Mr. Frog, in the context of your question, there was no need to refer to people by any color or race.
Listen,
It's
Judge,
wholly irrelevant.
we're not gonna be Joe Biden, wokeness, BLM and all that. Okay, we're beyond that.
Mr. Frog, you were asking the witness a question about people specifically with regard to their race as motorists, and I can see no reason that that is relevant at all in the context of people driving on the roadways of the state. And you must refrain from that sort of thing.
Well, I've had
It is
encounters with black
racially
people on the
derogatory,
road, Judge.
insulting.
On 3, 4, I don't know, quite 5 occasions. And there's a pattern, and I see the news. I listen to the news constantly for the last, ever since 2020, 2019. Or even before that, to the Trump presidency. And I see all that. And I've had situations which you're not familiar with on the road. I've been on that road a lot on the highway. And
And none of that is relevant, and I am directing you.
shove it under the carpet.
I'm directing you to stop referring to people, whether they're present in court or not, or whether they're jurors or court personnel.
Okay,
in those
Judge, I
derogatory
understand what you're
ways.
saying. I don't know how I can be more so polite in that regard.
And
but,
remember, you're asking questions here of a custodian of records. You're not, her scope of testimony is limited to that area.
well, I don't know what her scope is, how limited her scope is, Judge. That's why I'm inquiring. I don't know. I'm not gonna make assumptions. They're sending a 1-year, an employee that's been with the department 1 year. They can't answer any questions. Judge Buckley said, no, you're not gonna get no witnesses when I asked for DOL, DOT, and WASP. And there's another problem. The jury instructions say that you fail to appear, fail to comply, and fail to this and fail that. And that's one of the elements of the charge. And I have to challenge that. Otherwise, I'm not getting a fair trial.
You
On
can
top
ask
of-
the witness questions about the basis for the suspension. I believe you were doing that. And that doesn't involve anybody's race. Let's have Ms. Gronzo back in here, and I'm gonna have you resume the podium, Mr. Farag, and resume your cross-examination under the rules that I just expressed.
Yes, I believe that is the prosecutor's witness. And I don't know how do you subpoena someone from the Department of Licensing, is what they call it in Washington. Do you just subpoena the department as a whole and they just send somebody? I don't know. But I do believe it is the state's witness. Yeah, there's only 2 witnesses. This is the last one. Hello, everybody. While the jury's coming back in, if you haven't hit the like button already, please tap that like button. It'll make Detective Rachel really happy.
Thank you, Your Honor. Well, there's the motorist public involves people of different nationalities or different races. It involves young people, teenagers, and we've received information that the majority of the people in safety classes, for example, are teenagers. What,
Objection, relevance.
okay, what changes have been made in which areas in the driver's guide during the last 10
Objection,
years?
relevance.
Sustained. That question was previously asked, objected to, and the objection was sustained. So move on.
Now, whenever a traffic court sends you, what is it called that they send you that triggers a letter of suspension to the motorist? They send you, can you answer that question?
Could you restate it, please?
Well, the court sends you something and then you issue a letter of suspension to the motorist.
My department does not issue the letters themselves. We just print them for the CCDRs.
Which department does that then?
I believe I could not answer that question.
The have they dispatched staff that have been to a subpoena that have been with the department more than your 1 year?
Are you asking if they have in the past?
Yeah.
Yes.
And what's the length of their tenure? For instance,
Objection, relevance.
Sustained.
what can you tell us as far as is inflation having any effect?
Objection, relevance.
Sustained.
So your knowledge of the department is limited, correct?
Yes, there are a lot of laws.
And there's a lot of aspects to the department, how they handle driver licensing, right?
Yes.
Can you say, can you give us any information as far as usage of the HOV lane?
In what sense?
Objection, relevance.
Yeah, I was just gonna say that. HOV lane? He's gonna ask about speed limits next. Why is the highway only 65 miles per hour? Shouldn't it be 75? At what age do you need to be to get your
What can
driver's
you tell us
license?
as far as the driver's license having a street address versus a mailing address, such as PO box?
Objection, relevance.
Driving while suspended.
If
Got a
the
jury trial for driving while
motorist does
suspended.
not receive the mail from DOL at his mailing address because the driver's license requires a street address where mail is not received there, is it possible that the mail did not, was not received or by the motorist?
It is not up to the Department of Licensing to update the addresses of the license holder. We send the suspension letters to the most recent known address.
I don't know if they ever said why he was suspended. Did they? I know they went over the rules for what can
Now, the
potentially
knowledge
suspend your
test on
license.
the examination, if that has an effect on the suspension or it has an effect on reinstating your driver's license, would that invalidate the suspension?
Objection, relevance.
Well, then that makes sense why you brought up the SR22 then. I don't remember. I feel like I've seen this 3 or 4 times and I don't remember why his license was suspended, but that makes sense now.
Okay.
All right, now we got multiple.
Do you
things.
have any answers as far as the driver's guide advising motorists to be considerate?
Objection, relevance.
Sustained.
Now, there was a decision, by the Washington State Supreme Court regarding suspensions 25 years ago, maybe a little bit longer than that. And the Department of Licensing issued letters to motorists saying, hey, there's nothing, the decision makes it clear for you to reinstate your license. Do you know anything about that?
In what sense? Could you restate your question, please?
Well, the Supreme Court, the highest court in this state, Supreme Court issued a decision 28 years ago that invalidated all these suspensions.
Objection, relevance.
Sustained.
That has a direct bearing, Your Honor, on the validity of these suspensions.
Objection, sustained.
What would be your opinion? What would be the grounds for your ruling?
The deputy prosecutor raised the grounds of irrelevance, relevance.
I know.
Sustained the objection on that basis.
On just simply that,
Absolutely.
because there's a replay going on right now, suspending, invalidating these suspensions,
Mr. Frog,
and there could be
the
current
question
cases.
is irrelevant. It calls for irrelevant information. So please move on to your next question.
You know, what's relevant in your thinking is not relevant to the factual case.
Are you done with the witness?
Well, not yet, Judge.
All right, same here in Ohio. You have to have a physical address. You have to actually bring in utility bills to prove that you live there when you go to the DMV to, well, that's just change your address. I don't know if you need that. I don't know. It's been so long since I got my license. I don't know. I don't remember what exactly I had to do. I know that when I recently moved, I had to bring in a utility bill to prove that I lived at the address I was changing it to. But I don't know. But yeah, he gets really close to being a soft sit. I don't remember. I highlighted the comment a minute ago. He gets close. He just doesn't use the terminology, but he's right there on the border. He's right there.
Thank you for that.
I love that I paused
you
it
have
to answer that
any,
question, and then there was a minute of downtime. Oh yeah, I got a little worried there. I was just checking how much time was left in the video.
So the department endorses and accepts Miss Garzo. The Department of Licensing accepts, endorses anything brought to it from the district court. Is that correct?
In what sense?
In all senses. No questions asked.
Could you restate your question, please?
When you receive something from the court, which triggers a letter of suspension. Now, the docket, what is it called that you receive from the court?
I do not work in that department. I do not place suspensions on people's licenses.
That would be the other department, customer records support.
That would be who you could ask about it.
You can't answer anything in that regard.
I do not do that process. I do not place suspensions.
And that's a good question. I don't know. There's probably other ways to prove. I don't know.
So essentially, you're just the Department of Licensing is essentially just an extended arm of the court. You help them enforce the.
Objection. Sustained.
Sorry about that, Judge. This microphone is directly in my way. This thing could be a lot bigger. Do you see how crowded I am?
No one cares. This witness just wants to go to lunch. Let her go home.
You, Miss, and I hope I'm pronouncing your name fairly correctly, Miss Garzo.
Gronzo.
Excuse me,
Gronzo?
Granzo.
Yeah.
Okay, there's an N there that I left out. Sorry about that,
Yeah, okay.
Miss Garanzo.
It'll be fun, they said.
This case, for it to meaningfully proceed forward to the jury to decide, requires somebody coming on behalf of the department, such you are doing today, that has more knowledge and more ability to
Objection,
answer
Your
the
Honor.
questions. Is
This
it
sticks to
possible
law.
that we can have,
Sustained. The jury will disregard the first part of that. You may proceed with everything after is.
okay, let me see if I can do that, Judge. Thank you. Can we have your subpoena transferred over to another staff member that is more knowledgeable,
Objection. Your
such
Honor.
as,
Sustained.
okay, we're not getting adequate answers. Would you tell your secretary that we need a more,
Objection. Sustained.
okay, your experience and your knowledge is too limited.
Objection.
Can you
The jury will
tell your
disregard the
secretary,
statement from Mr. Frog.
your bosses, to provide the court, to provide us for this trial, someone that has more experience and more knowledge?
Mr. Frog, are you done asking the witness questions?
Well, I didn't get an answer, Judge.
I sustain the objection. You're not going to get an answer to that question.
So we
You
have
have-
to accept
Do you have any questions?
Whoever they
for the
send?
witness?
Yeah, I'm gonna see here if I got anything. I'm not sure if I have, excuse me, I'm not sure if I have anything else. Any other written lists?
No one's moving.
Now,
There
self-insured,
we
Objection, Your Honor, relevance.
Sustained. This has been sustained before, Mr. Brock, so please move on to another subject.
Do you guys remember during the Heard Depp trial? There's a lot of parody videos where songs were created, but the objection hearsay song. All I keep thinking is that song during this trial. Objection relevance. We need to remake that into objection relevance.
Madam, this notice of suspension refers to a court name in Lewis County as Lewis County District Court. Now, if that's the improper venue, improper court, it should be Thurston County.
Objection.
Sustained.
No, it's the state's witness. He didn't bring forth any witnesses. It was one of the complaints he made. He wasn't able to subpoena any witnesses, is what he said. I believe he made that argument when he tried to push the start time back, the start date, maybe. Oh no, maybe I did actually pause it this time. Yep, I did. When I'm recording court, sorry, I shouldn't say that word. When I'm grabbing court clips, I generally have my wireless earbuds in, and they're very sensitive. If I tap them, it pauses the screen, and I'm not always sitting in front of my computer, so I do that a lot. All right, let's move on. Thanks, Jody. I appreciate that.
What can you tell us, Miss? What can you tell us as far as the occupational restricted license will not be valid?
Objection, Your Honor.
Sustained.
If he were here right now, he would make a plan and follow through. That's what Brian Boitano would do. I'm guessing that's a South Park reference. I like it. I like it.
So, Miss Garanzo, it's from the date of the notice of suspension to the date that driving privileges will be suspended is about a month and a half. Is that normal practice?
It varies, but that is normal, yes.
So from the letter you issue, you provide about a month and a half window for the motorist to get back with you.
Yes.
But a request for administrative review is not really going to go anywhere.
Objection.
And this question has already been answered. So sustained.
Yeah, standby counsel is Mr. Pazderka. He's just a public defender. Not just a
Yeah, I
public
only
defender. He
received
is a public
this
defender.
today, Judge. I mean,
He's good though. I like him.
Mr. Frog, if you have questions for the witness, we've asked them. You're done asking questions. I'm going to turn it over to the deputy prosecutor.
and he'll be allowed to question the madam.
Well, it'll be his turn to ask questions on redirect if he so chooses.
Anybody want to take bets on if the state redirects this witness at all?
Now, the court must submit proof to the department that
I don't have more on him. I know Law Talk with Mike covered a lot of his hearings leading up to this, but I don't have more on him. Supposedly, he has a trespassing jury trial starting Monday. After this video completes, we'll see if that happens.
Judge, when are we going to break for lunch?
My question to you is, do you have any further questions for this?
I'm getting prepared to ask my next question, but when are we going to otherwise break for lunch?
I need you to.
Objection relevance.
Well, I want to know how much time is remaining.
To the witness. Please.
I do not. He probably does, Lane. I don't know. I just know I've seen this guy before the trial started, and I don't remember where I saw him before. So it was either OSG or Mike's channel. He has brought up lunch about a dozen times, though. Maybe he's hungry. All right, guy. Let's go.
Mr. Frog, if there aren't any more questions, I'm going to turn this over to the deputy prosecutor for redirect.
Okay, Judge.
Mr. Robbins, any question?
Nothing from the state, Your Honor.
Then, Ms. Grimes, you can step in.
Am I being released?
Yes, you're excused.
Thank you.
Thank you. Thank you for coming, madam. Have them send someone with more experience.
That's it.
Wow.
'Cause we're not getting anywhere.
I need to talk to your supervisor. Yeah. It's a good point.
And to answer your earlier question, this is the point that we're going to break for lunch. So members of the jury, I'm going to excuse you for a lunch break. I'm going to be back here at 1:30 in the jury deliberation room. And I'll remind you of my earlier advisements, not to discuss this case among yourselves or with anyone else until it's finally submitted to you for the decision. Enjoy your lunch. See you at 1:30.
All right. I believe we move on. They may talk for a little bit longer. I don't remember.
Ready to resume at 1:30. Are there going to be any more witnesses for the state?
Oh, no more witnesses for the
The
state.
state rests, Your Honor.
So the state resting at this point. All right. Then when we reconvene, it'll be your turn, Mr. Frost.
Now, we gotta be back at 1:30, Judge. Now, is there, are we gonna run up until 5?
Well, I don't know. It's kind of, it depends. You don't have any witnesses besides yourself, right?
Yeah, I wasn't able to subpoena
So you're,
somebody more knowledgeable at DOL as well as DOT as well as State Patrol.
but you're
Mainly.
planning, I think you said before, you're planning to testify.
Yeah, I normally I do, but we have to cut off at a certain time.
But we're
right?
going to conclude this trial today. So when you, after you testify, then if the state doesn't have any rebuttal witnesses, then I'm going to instruct the jury as to the law, and then it'll be time for closing arguments and deliberation.
And how much time am I gonna be allowed to testify?
Well, I'm not setting a time limit on your testimony. You can give any relevant testimony.
And it's all mud over the water now as far as the trooper.
Yeah, that's done.
He's gone, right? He's not, we can't recall him.
His testimony is concluded.
He's a nice officer. I hate to, you know, to interrogate him, but I just has an effect on the trial. Judge. It has an effect on the testimony.
get yourself some lunch, take care of your dogs, and we'll pick this back up again at 1:30. Not join.
All right. So they broke for lunch. That was the end of that video, or the end of that. Yeah, it was the end of that video on YouTube. Now, this is when you have to pay attention. They just broke for lunch. They're coming back. I will say that he was late to everything, and he got reprimanded by the judge for always being late. He was 10 to 15 minutes late to jury selection, to his final conference. He was late to everything. This is when it gets fun.
Us. Good to go. Okay. All right, we're back on the record with State versus Farag. It's now 1:53. Mr. Farag is still not joined us. Present in court, Deputy Prosecutors Thompson and Robbins, and standby counsel for Mr. Farag. All right. As far as how we're going to proceed from here, the state has requested that the trial continue on in Mr. Farag's absence. In my estimation, that is an appropriate thing to do if it's proper to find that Mr. Farag has voluntarily absented himself from court after the trial's commenced under Rule 3.4D, and cases decided under that, including State versus Crafton. Mr. Farag has been advised on multiple occasions that his presence is required. He's been advised of the time that he's expected to be here and ready to proceed with the trial. And he has now, for the third time in a row, failed to be here on the time appointed, and it's now 25 minutes past the time appointed. He also indicated earlier today on the record on multiple occasions that if he was unhappy with the court's rulings or with the trajectory of the proceedings, he would just leave. He was advised that if he were to do that, that the trial would proceed in his absence. I think from that, it's reasonable to conclude that he has voluntarily chosen not to be here today, not to be here for the remaining portion of his trial. Before we proceed any further on that, Mr. Thompson?
Yes, Your Honor, and we do have a weird bit of circumstances in the fact that he is a pro se defendant.
Right.
And so, yes, the state's request is to proceed absentia. I think the court had briefly discussed one of the cases, which was State v. Crofton, regarding when trial commences. I think the also pointing out State v. Hammond, which indicates trial in absentia is permissible only when the defendant becomes absent after trial begins, which then led us to Crafton. Further, I would cite State v. DeWeese, or DEWEESE, 117 Win 2D 369, which, and I won't belabor the point too many, or too much, but essentially talks about the court's authority to maintain order in the courtroom and about a defendant being removed, and then further goes into when a pro se defendant does not have standby counsel and voluntarily refuses to participate in the trial, courts have found a waiver of the right to counsel. I point that out because in this case, he does have standby counsel. And so while it may not be an express waiver of his right to counsel, I do want to point out that the courts have felt that they can proceed on a pro se defendant who fails to appear in absentia. And so that is what, at least in part, why the state is still asking and recognizing that we don't have an attorney here to proceed for him.
Just to add to that, Mr. Farag had also indicated earlier today when I'd asked him to consult with Mr. Pazderka that he was declining to do that. He emphatically stated that Mr. Pazderka is not his attorney. So I don't think he believes subjectively that he is represented in any capacity. Before I make any decision on continuing though, Mr. Pazderka, if you think it's appropriate, only if you do think it's appropriate, I'll hear from you on the issue.
Your Honor, I have nothing to add and have no objections to any thing that has been presented.
All right. So Mr. Farag has quite obviously waived his right to be present with full advisement of the consequences of what would happen if he were to do that. So I'm finding that he has voluntarily absented himself. The trial clearly has already commenced and we're in the second day of trial. In fact, the only part of the trial left to present would be, now that Mr. Farag's not here to present his own case, would be instructions and closing.
Thank you, Your Honor. And with that in mind, at this time, the state would request the court to note the FTA of the defendant order a bench warrant, but reserve issuing that bench warrant until after a verdict's returned, or when we recess for the day, whichever happens first. That way, if for some reason the jury returns a not guilty verdict, obviously no warrant would be appropriate. But if they return a guilty verdict, we'd ask that the warrant already be ordered. And just,
I think that's a wise course of action, and I'll make that finding that he has failed to hear. The warrant is authorized, but it will not be issued pending verdict of the jury. All right, then I intend to just number the instructions here. We'll have them copied for the jury.
Your Honor, if I may ask, just for clarification for my purposes, and maybe clarity for the record, that the court is accepting that Mr. Farag did waive his right to counsel, and that the court is not asking standby counsel to step in.
He did. He waived his right to counsel previously. He was given the pro se advisements about the dangers and disadvantages of proceeding, he made it clear that he wanted to proceed pro se. He's acted consistently with that entirely throughout the course of these proceedings. And really, Mr. Pezdirk, I think it'd be fair to say that he's repudiated you as standby counsel even. So he has very, very clearly indicated that he intends to represent himself, and he's made his own choices in that regard.
Thank you, Gary.
All right, these instructions as proposed by the state are numbered. I think that they are appropriate and they're pattern instructions. I included the instruction in here regarding no prejudice from the defendant not testifying. So let's make everything.
Yeah. Ask him for-
Phil, I've been laughing for 5 straight minutes
Remind him.
from that comment. That was funny. He's gonna show up late and just start berating the janitor. There's no one here. I'm gonna yell at somebody. Yeah, he doesn't show up. Never comes back. After all of that time, wasting all of that time, he did not come back after lunch. Maybe that was his plan all along. He wanted to break for lunch. He said earlier he had to go to the bathroom. Maybe he was just planning on running. But yeah, he has a jury trial that's supposed to start on Monday. He now has a bench warrant out for his arrest. So we might see him in a jury trial wearing orange. Who knows? No, Sally, we're not done yet. They still walk through the rest of the trial, which I'm guessing they have to for appeal reasons maybe, but it's a trial. So that's what they were just discussing in the last clip. So the judge is going to read the jury instructions. Then the state is still going to go through with their closing, and the jury is still going to come back with a verdict. So there's about 15, 20 minutes left still of this video. I told you it was a long one. I wanted to finish this, move on to other things. If you haven't done so already, please like and subscribe. Do your jump kick backflips. If you'd like to donate, Linktree is in the description. But yeah, like I said, still about 15, 20 minutes left.
Thank you.
When you came into the courtroom, you should have found on your seat a package entitled Court's Instructions to the Jury. You've now heard the entire evidence portion of this case. The defendant, Mr. Farag, has declined to present evidence and is declining to attend the remainder of the trial. These will be the court's instructions to the jury. Please feel free to follow along. It is your duty to decide the facts in this case based upon the evidence presented to you during the trial. It's also your duty to accept the law from my instructions, regardless of what you personally believe the law is or what you personally think it should be. You must apply the law from my instructions to the facts that you decide have been proved and in this way decide the case. Keep in mind that a charge is only an accusation. The filing of a charge is not evidence that the charge is true. Your decisions as jurors must be based solely upon the evidence presented during these proceedings. The evidence that you are to consider during your deliberations consists of the testimony that you have heard from witnesses, stipulations, and the exhibits that I've admitted during the trial. If evidence was not admitted or was stricken from the record, then you are not to consider it in the verdict. Exhibits may have been marked by the clerk and given a number, but they do not go with you to the jury during your deliberations unless they've been admitted into evidence. The exhibits that have been admitted will be available to you, the jury. One of my duties has been to rule on the admissibility of evidence. Do not concern yourselves during deliberations about the reasons for my rulings on the evidence. If I have ruled that any evidence is inadmissible, or if I have asked you to disregard any evidence, then you must not discuss that evidence during your deliberations or consider it in reaching the verdict. Do not speculate whether the evidence would have favored one party or the other. In order to decide whether any proposition has been proved, you must consider all of the evidence that I have admitted that relates to the proposition. Each party is entitled to the benefit of all of the evidence, whether or not that party introduced it. You are the sole judges of the credibility of each witness. You are also the sole judges of the value or weight to be given to the testimony of each witness. In assessing credibility, you must avoid bias, conscious or unconscious, including bias based on religion, ethnicity, race, sexual orientation, gender, or disability. In considering a witness's testimony, you may consider these things: the opportunity of the witness to observe or know the things he or she testifies about, the ability of the witness to observe accurately, the quality of a witness's memory while testifying, the manner of the witness while testifying, any personal interest that the witness might have in the outcome or the issues, any bias or prejudice that the witness may have shown, the reasonableness of the witness's statements in the context of all of the other evidence, and any other factors that affect your evaluation or belief of a witness or your evaluation of his or her testimony. The lawyer's remarks, statements, and arguments are intended to help you understand the evidence and apply the law. It is important, however, for you to remember that the lawyer's statements are not evidence. The evidence is the testimony and the exhibits. The law is contained in my instructions to you. You must disregard any remark, statement, or argument that is not supported by the evidence of the law and my instructions. You may have heard objections made by the lawyers during trial. Each party has the right to object to questions asked by another party and may have a duty to do so. These objections should not influence you. Do not make any assumptions or draw any conclusions based on objections. Our state constitution prohibits the trial judge from making a comment on the evidence.
The jury's off to the
It may be
right.
appropriate or improper for me to
That's who he's
express
talking
by
to.
words or conduct my personal opinion about the value of testimony or other evidence. I've not intentionally done this. If it appeared to you that I've indicated my personal opinion in any way, either during trial or in giving these instructions, you must disregard this entirely. You have nothing whatever to do with the punishment that may be imposed in case of a violation of the law. You may not consider the fact that punishment may follow conviction except insofar as it may tend to make you temporal. The order of these instructions has no significance as to their relative importance. They are all important. In closing arguments, the lawyers may properly discuss specific instructions during your deliberations, thus consider the instructions as a whole. As jurors, you are officers of this court. You must not let your emotions overcome your rational thought process. You must reach your decisions based upon facts proved to you and the law given to you, not in sympathy, prejudice, or personal preference. To assure that all parties receive a fair trial, you must act impartially with an earnest desire to reach a proper verdict. Instruction number 2, as jurors, you have a duty to discuss the case with one another and to deliberate in an effort to reach a unanimous verdict. Each of you must decide the case for yourself, but only after you consider the evidence impartially with fellow jurors. During your deliberations, you should not hesitate to re-examine your own views and to change your opinion based upon further review of the evidence of the instructions. You should not, however, surrender your honest belief about the value or significance of evidence solely because of the opinions of your fellow jurors. Nor should you change your mind just for the purpose of reaching a verdict. Instruction number 3. The defendant has entered a plea of not guilty.
It's a little
Plea
bit
puts
longer
at
than a
issue
minute,
every element of
but I
the
think it
crime
was only
charged.
5 to 10
States
minutes.
The plaintiff has the burden of proving each element of the crime charge beyond a reasonable doubt. The defendant has no burden of proving that a reasonable doubt exists as to its elements. The defendant is presumed innocent. This presumption continues throughout the entire trial unless during your deliberations you find it has been overcome by the evidence beyond a reasonable doubt. A reasonable doubt is one for which a reason exists and may arise from the evidence or lack of evidence. It is such a doubt as would exist in the mind of a reasonable person after fully, fairly, and carefully considering all of the evidence or lack of evidence. If from such consideration you have an abiding belief in the truth of the charge, then you're satisfied beyond a reasonable doubt. Instruction number 4. The defendant is not required to testify. You may not use the fact that the defendant has not testified to infer guilt or to prejudice him in any way. 5. The evidence that has been presented to you may be either direct or circumstantial. The term direct evidence refers to evidence that is given by a witness who directly perceives something that is at issue in this case. The term circumstantial evidence refers to evidence from which, based on your common sense and experience, you may reasonably infer something that is at issue in this case. The law does not distinguish between direct and circumstantial evidence in terms of their weight or value in finding facts in this case. One is not necessarily more or less valuable than the other. Instruction number 6, a witness who has special training, education, or experience may be allowed to express an opinion in addition to giving testimony as to facts. You are not, however, required to accept his or her opinion. To determine the credibility and weight to be given to this type of evidence, you may consider, among other things, the education, training, experience, knowledge, and ability of the witness. You may also consider the reasons given, the sources of his or her information, as well as considering the factors already given to you for evaluating the testimony of any other witness. Instruction number 7. The person commits the crime of driving while license suspended or revoked in the 3rd degree. He or she drives a motor vehicle while his or her driver's license or driving privilege is suspended or revoked because the person failed to respond to a notice of traffic infraction, failed to appear at a requested hearing, violated a written promise to appear in court, or failed to comply with the terms of a notice of traffic infraction or citation as provided in 26.20.285. Instruction number 8. The convicted defendant of the crime of driving while license suspended or
I would have
revoked
stayed for lunch.
each of the following the elements of the crime must be proved beyond a reasonable doubt.
They wanted to
One, that
go.
on or about July 16th, 2021, the defendant drove a motor vehicle. And 2, that at the time of driving, the defendant's driver's license or driving privilege was suspended or revoked because A, the defendant failed to respond to a notice of traffic infraction, failed to appear at a requested hearing, violated a written promise to appear in court, or failed to comply with the terms of the notice of traffic infraction.
Yeah, he was a
citation
prosecutor before a
as
judge.
provided
I don't know
in
what snapped is, though.
46.20. Yeah, that the driving occurred in state Washington. Thursday. If you find from the evidence that elements 1, 2, and 3 have been proved beyond a reasonable doubt, then it will be your duty to return a verdict of guilty. On the other hand, if after weighing all the evidence, you have a reasonable doubt as to any one of elements 1, 2, or 3, then it will be your duty to return a verdict of not guilty. Instruction number 9. When you begin deliberating, you should first select a presiding juror. The presiding juror's duty is to see that you discuss the issues in the case in an orderly and reasonable manner, that you discuss each issue submitted for your decision fully and fairly, and that each of you has a chance to be heard on every question before you. Deliberations are to occur only in the jury room when all 6 jurors are present. You are all officers of the court and must evaluate the evidence with an open mind, free of bias or prejudice. If during your deliberations you become concerned that discussions are being influenced by preconceived bias or prejudice, you must bring this to the attention of the other jurors so that the issue be fully discussed among all members of the jury. During your deliberations, you may discuss any notes you've taken if you wish. You've been allowed to take notes to assist you in remembering clearly, not to substitute for the memory, not to substitute for your memory or the memories or notes of other jurors. Do not assume, however, that your notes are more or less accurate. You will need to rely on your notes and memories for the testimony presented in this case. Testimony will rarely, if ever, be repeated for you during your deliberations. If after carefully considering the evidence and instructions, you feel the need to ask the court a legal or procedural question that you've been unable to answer, write the question out simply and clearly. For this purpose, use the form provided in the jury room. In your question, do not state how the jury is voted. The presiding juror should sign and date the question you give the clerk. I'll confer with the lawyers to determine what response. If you'll be given the exhibits submitted into evidence, these instructions in the verdict form for reporting the verdict. Some evidence and visual aids may be used in court, but will not go with the jury room. The exhibits that have been admitted into evidence will be available to the jury room. You must fill in the blank in the verdict form, the words not guilty or the word guilty, according to the decision to reach. Because this is a criminal case, each of you must agree to return a verdict. When all of you have so agreed, please fill in the verdict form to express your decision. The presiding juror must sign the verdict form and notify the clerk, who will bring you into court to declare the verdict. We'll hear closing arguments, counsel for the state. So give your attention to Mr. Rob.
All right. Before he starts his closing argument, I am going to peace out. As always, I'm not leaving. I'll still be in chat. I'm just not going to pause it anymore for the rest of the video. So thank you all for coming. Thank you for watching. This is the final chapter. I will keep my eye out on Monday to see if he shows up for his trespassing trial, but I'm going to say he's probably not going to show up. He has a warrant out for his arrest. He knows he has a warrant out for his arrest now. So thank you, everybody, for stopping by. If you haven't done so already, please hit that like button. If you haven't already, subscribe. I would appreciate both those. Do your jump kick backflips. And as always, link trees in the description. If you want to throw a little money my way for all my hard work, I would very much appreciate it. If not, no pressure. But until next time. Oh, Rachel, I got you. I got you. I just looked at my phone and I still haven't taken away the notification. So right when this is over, I will search for that link for you. All right. Now, until next time. Bye.
Good amount of information in this file. And I would like to just narrow it down and briefly focus on one important jury instruction, which is jury instruction number 8. It says that if you find that elements 1, 2, and 3 have been proven beyond a reasonable doubt, then it is your duty to return a verdict of guilty. Let's just go through them briefly. Element 1, that on or about July 16th, 2021, the defendant, being Mr. Nabil Farag, drove a motor vehicle. How do we know he did that? Trooper Jackson testified as to seeing Mr. Farag drive the vehicle, pulling him over, and identifying him by his Washington State driver's license. Next, that at the time of driving, the defendant's driver's license or driving privilege was suspended or revoked. When you go back to the room, you will take with you States Exhibit 2 and 3. 3 is the defendant's driving record. I encourage you to go to the second to last page, also labeled page 8 of 9, which says at the bottom, action taken suspension. Start date, June 12th, 2021. End date, January 13th, 2022. The date, July 16th, 2021, exists between these two dates. Next, 2A, the defendant failed to respond to a notice of traffic infraction, failed to appear at a requested hearing, violated a written promise to appear in court, or failed to comply with the terms of a notice of traffic infraction or citation as provided by RCW 46-2289. I encourage you to turn to States Exhibit 2, which is a notice of suspension. At the top, it will say that it was sent to Mr. Nabil Farag. And just under that, it will say that we will suspend your driving privilege until you comply because you failed to respond, appear, pay, or comply with the terms of a citation under the authority of 46-2289. And about 2/3 of the way down this notice of suspension, you will find the violation number. I encourage you to look back at that second to last page of States Exhibit 3 and match that violation number with the reason for suspension. Lastly, that the driving occurred in the state of Washington, county of Thurston. How do we know that happened? Trooper Colin Jackson said, I pulled him over where? Saw him on milepost 108, exit 108, and pulled him over in Thurston County. I encourage you to return a verdict of guilty. Thank you.
Members of the jury, at this time, you can go with the clerk to the jury deliberation room, select a presiding juror, and deliberate on your verdict.
They are super nice, except for the whoopee cushion with the up and down. Or every time you shift your butt in the middle of trial and it sounds like you're passing gas yet again. And of course, it's like the one thing that carries properly in here.
County District Court is back in session. Commissioner Wolf presiding.
Be seated, please. Did you already take this from him? Okay. All right. Let's bring the jury in.
And
Your Honor?
Question?
Yes, Your Honor, if you could, let's take a request, if you could tell the jury that this is my second trial and ask if any of them would be willing to stay behind.
Yeah.
Thank
Yeah,
you.
after the verdict.
After the verdict.
yeah, I'll do that. I will do that.
I'm gonna turn that TV on.
Be seated, please. All right, and can the presiding juror please identify yourself? As the jury reached a verdict.
You have your.
All right, and did you deliver this verdict form to the clerk?
Yes.
Okay, thank you. Verdict, this is State of Washington versus Nabil Farag, 1A505393. We, the jury, find the defendant Nabil Wagdi Farag guilty of the crime of driving while license suspended or revoked in the third degree as charged in count 1, dated today and signed by the presiding juror. All right, the court will receive the verdict and enter judgment on it. And members of the jury, at this point, I'm thanking you for your service and discharging you. Completed your task as jurors. We appreciate it. Before you go, I did want to tell you that Mr. Robbins, the deputy prosecutor who tried this case, this is his second trial. He's newly graduated from law school. So he would appreciate it if you were willing to stay behind and talk to him about the trial and give him any feedback you might have. That can really help new attorneys in their progress. That's not required, but I'm just putting it out there if you're willing to do it. So once again, thank you for your service, and you're released from all my prior restrictions and you're discharged.